Good morning. Could the user who just called in 216-256-7020 please let us know your name? And just to let you know, it looks like you are still muted. Good morning. Thank you for joining. Apologies for the technical issues. We are giving everyone a few extra minutes to log in with new Zoom access. So we will be starting the meeting as soon as we can. Thank you.
Good morning and welcome to the Victim Compensation Board public hearing on the proposed revisions to the CalVCB regulations. We apologize for the technical difficulties that we have experienced this morning. My name is Sarah Harbarger, and I'm a senior attorney at the California Victim Compensation Board. And here with me, I have Neil Innes, a staff service manager. This hearing is an opportunity for members of the public to comment on the proposed revisions to the California Victim Compensation Board regulations. Specifically, Regulations Title II, 649.4, 649.7, 649.15, 649.16, 649.18, 649.19, 649.24, 649.28, and 649.50. CalVCB will listen to public comments, but will take no action or respond to the oral comments or written comments during the public hearing. The hearing will be held from 10 a.m. to 1 p.m. Public comments may be limited to 5 minutes per an individual. The hearing is being recorded and will be later transcribed by a court reporter. For those of you in the room who are appearing to offer public comment, the microphones at the podium and tables are directional and require that you hold them fairly close to your mouth and speak directly into the microphone to ensure that your testimony is captured by the audio equipment. For participants who are appearing via Zoom, if you cannot hear the presenter, please use the comment feature to note, and staff are monitoring these comments in real time. For participants who wish to make a comment via Zoom, please use the raised hand feature if you'd like to make a comment, and you will need to unmute yourself. In order to accurately record the proceedings at the start of your comment, please state your full name and spell your last name for the record. Please wait until the other person has finished speaking before you begin speaking, as the recorder can only take down each person's words with only one
Good
person.
morning. Thank you for joining. Apologies for the technical issues. We are giving
Please do not use gestures as they cannot be accurately recorded. If you would like to submit a written comment during the hearing, you may turn them in person to Andrea Burrell, who is present in the audience. If you would like to turn them in during the hearing for written comment and you're not here in person, please use the email in the public notice. And so we are going to get started with our first in-person public comment. If you would like to make your comment.
Good morning. I thought there would be a lot more people.
Would you like to sit or stand? Okay, that sounds great. So just take a seat and please make sure that the microphone is as close to your face as possible. Thank you.
Morning. My name is Margaret Petros. Last name is spelled Petros. I'm the executive director of Mothers Against Murder, victim helping agencies with emphasis on helping families of murdered victims. And we are passionate about making sure that victim compensation is made available to families for funeral and burial expenses, as well as other benefits that are eligible. Any changes are important for the public to share their comments and be involved. And thank you for holding this session. I know I asked for it, and I believed more people would be present that care about this, but I don't see many here. It, in a way, tells us about how the California public are not engaged in this process, and so important to be. I would like to start from the beginning on page 1 of the regulations and quickly and briefly um, the beginning, which I fully understand the regulation have to follow the law about paying victims who are on parole, on probation, who have been convicted of a crime. Um, and the law would have to be changed. And I hope someday it will be, because uh, all victims should be treated with the respect and dignity they deserve. If they were innocent victims of a crime, their expenses should be paid. They should be eligible for victim compensation. And I hope this program advocates for that with a legislator. And I know there are others as well as our agency who wants that to happen. As a civilized nation, all people who are victims of crime should be helped. We should not be differentiating. This is a good victim, this is a bad victim. It's the wrong message to send in every way. So I hope the law changes so where regulations are more appropriate. I do object to the subsection F, where the board shall not grant compensation to an applicant to any expenses due to a victim's death or injury while incarcerated or in a correctional institution. I personally have dealt with this some 20 years ago when I was at the manager at the victim assistance program. And I remember my director of victim witness was, a probation officer before. Remember this so clearly. We talked about it and we researched it. He was a probation officer who said, once somebody dies, their records ends. It closes legally. I remember it was by abatement, then no longer they're on probation parole. So the funeral burial expenses happen afterward and they were eligible. And I know I convinced this program to keep paying those expenses. They agreed that. Last night I did a quick search and it says when felons die, they are no longer on parole or probation. And it's again, I'm not a lawyer, but the legal term was abatement. And please look carefully into that. We really want if someone is raped in prison and they're tortured and killed and they die, then that's it. They're no longer. So this part follows within the law because the law says, the statute says you can't pay those who are on probation and parole. But once it ends, that's it. No one can do anything about it. So we, as an agency and personally as a victim advocate for many years, I'm objecting to this regulation. And then going further down, just quickly on supporting document when another person files on behalf of the victim, I appreciate if there are specific documents that are built in the regulation, such as a power of attorney, then people can file with that supporting document. When it's just general, then it's open to interpretation, and that always causes problems. On page 3 would be bullet number 9. So the applicant, when represented by an attorney or an authorized person, the application must include the name, address, and the number of the representative. Yes, if that representative starts the application, then sure. But in many instances, by the time the client comes to our attention, an application has already been filed. And I wanted to make clear that what's happening now is a forum that's built by the program, CalVCB, uh, just signed by us as a representative, and it makes a record, and everything is, you know, a representative is keyed in the system then. That's the best way of doing it. I am concerned about duplicating applications. First, it's inefficient. It makes it harder on the victim, on us as the representative. Who would complete a brand new application? No other system out there, if there is a change of representative, would require a brand new application. The courts, if there's a petition filed, a complaint, a complaint would not be refiled again, but a change of representative forum, or just adding another representative. In many cases, I mean, victims can have more than representative. We get involved for some reason, then filling out the forum is all that's needed. I'm also worried if an application is filled out again and sent out with a new representative, it would be duplicating in the system. Already looking at annual reports, I see some files that are duplicates. It's cost more money, staffing time, and all that's totally unnecessary. It's making it more difficult on the victim and on the representative. So please keep it the way it is now. It's working fine. On page 4, and this is, I know it's been there for many years to for crime reports to victims are encouraged and to obtain the crime report and crime documentation, which is good. But the truth and the reality is very difficult, if not impossible, for victims to get these reports. The emphasis on always it's the program that is to verify and obtain records, especially local victim witness offices. They are in there within a stroke of a key, they can get these information. So don't depend on victims who are traumatized and suffering, and most of them have no clue how the criminal justice system works. Especially in our area of work, homicide cases, police departments do not release records. Yet it's easier for a state agency who has the law on their side saying that when they make a request, it has to be fulfilled within 10 days. So the emphasis on that, it's very important, and we'd really appreciate that. Just going through my notes here. There was a section about every field has to be completed on the application before it's considered and accepted as complete. That is another thing that is of concern to me because, again, not everyone can fill out an application with every single thing. For example, a social security number. Some don't have social security numbers, don't, and I know it's not actually required, but it's on the application. So my concern is when you clarify that in the records and in the regulations, somebody will follow that regulations, the staff will and deny that claim because the application is incomplete. There are many reasons. Following up, making sure that staff follows up to complete that application. It's easy to do. It's the right thing to do. We're here to help victims. shouldn't be making it difficult. And, one field on the application is not complete and it's a problem. Um, and, again, it needs some training to the local victim witness offices who are the majority offices that bring the claims in the CalVCB. Then they need to be filling it out. Let's not put it on the victims. I think the final comments I have is under on page 7, section 649.24. Reimbursements to service providers and ineligible for reimbursement. This is the first time I see such extensive language on ways that service providers would not be eligible. It's just too heavy handed. As is, it's very difficult to find mental health therapists to treat our victims. The payment is so low. And you pay a psychiatrist, so it's about $125 an hour. We're in the Bay Area, San Francisco Bay Area. I cannot find any therapist, a psychiatrist under $350 an hour. To this language, it's so long, and the really message it gives is they are defrauding the program. That's how I'm reading it. They provide false information. If they don't abide by the regulations and the statutes. How many people out there know about the regulations and the statutes of CalVCB? As a trained, certified victim advocate for nearly 4 decades, I still have to go and read the statutes and regulations to find some answers. So you are expecting and holding the providers of services responsible to know about these regulations. It is just too much, in my opinion. And again, how many providers are willing to treat crime victims as is? There is so many demands on providers to complete so many different forms that are difficult to complete as is. Really, this regulation on providers, I think it's insulting to many good people out there, providers of services, doctors, psychiatrists, psychologists, people who want to help victims. But if they're held to all these standards, plus they are licensed, let their licensing agency deal with them. If there is a problem, if there is really fraud, there is a venue for you to report them, but not, have these heavy-handed mandates on service providers. It just doesn't sound right. It's just really unnecessary. I was thinking and reading these regulations, thinking, how many frauds have I came across by providers? I managed the Santa Clara County Victim Assistance Program for 20 years, and I was very much a hands-on experience manager, processed claims. I could think in 20 years, definitely under 7 providers that there was an impression they committed fraud. And I have reported a couple of them. but really there is no it's very difficult to figure out this program. It's difficult to understand it. How many providers or even victims are going to sit and think, how are we going to want to defraud this program? I would love to see statistics. If I'm wrong, how many do you have? What for that is that what gave the reasons for this regulations? I'm really interested in dealing with the community of providers in a much more um, friendly, professional way, and not bring this onto them. Thank you so much for the opportunity for listening. We appreciate it. We are again passionate. And I go back one more time about treating all victims the same and not separating victims. And I personally and professionally think anyone who is convicted of a crime, why, and then they're still innocent victims. And I want to share one story with you. That's what really made my impression many years ago. I was all for it many years ago. Like, yeah, they're felons. Why should they get paid from victim compensation? There was a woman who came to our office who was raped and could not get her claim allowed because she was a felon on parole. And about a week later, she got killed right outside our office. And it was a bus station that we heard of. The entire office was traumatized by it. I will always remember that case. And thinking, what if we really could have helped her? She was an innocent victim of rape, could not get the help. And I am pretty sure if we spend more time, the legislators and voters, California voters, have always intended to have more services for crime victims and to treat all victims with respect and with dignity. And that's what Marcy's law starts with as well. Thank you.
Thank you very much for your public comment. I believe that is the only public comment in person. Or I'm sorry, we have one more in-person public comment.
Good morning, Sarah and Neil. I'm going to make this public comment anonymously because I believe members of the public should have that right. So I agree with Margaret. I think that the board should grant compensation to a victim, a murder victim, or any victim, even though they became a victim of a violent crime while they were incarcerated or on parole or have some type of criminal record, because that event is separate and we don't need to make them, they're already paying for their crime in another way. We don't need to also make them pay by not giving them the compensation they deserve. And someone else did something wrong to them, they should get the support. They're already paying for what they've done in the past. And the second reason is that there's still other innocent victims involved when someone who's incarcerated gets murdered, like the family members. And the loss of a loved one, that counts. That's a big pain. You're a victim if you lose a loved one to murder. And so a funeral is could be very important in the healing of a family member who lost a loved one to murder. And an innocent family member with no criminal background, why should they be punished? And why shouldn't they be compensated for the funeral of their loved one? Um, So that's a second reason to consider giving compensation to victims even though they have a criminal background. And the third reason is that Cal VCB has enough money to do that, so I don't think that's a good excuse. Because I've read the annual reports that you guys send out every year. Thank you for doing that. I think it's really important to be transparent. And there's millions of dollars unused. So you definitely have the resources. And the third the other thing that I wanted to bring up was about something that Margaret also mentioned. I also agree with her that it doesn't make sense to have a victim redo their Cal VCB application if they decide to if they decide to um, ask a victim advocate to represent them, they shouldn't have to redo an application with the victim advocate's information. They should just be able to, sign the paper authorizing the victim advocate to represent them. It's a waste of resources because it's just more paper being printed out unnecessarily and a waste of time as well. And I think that there's already so many unnecessary papers in the doc in your records because I volunteered for an organization that advocates for victims of crime and represents victims um and so I've seen the records that you guys send out to victims if the victims ask for their records that you have of their application, and it's just so many duplicated papers. It's really hard to go through, and I just can't imagine how much more complicated it would be to make sense of a victim's case if their application is going to be duplicated in that record. And the way it looks on our end, it's sometimes the application is already duplicated in that record, even though they didn't fill it twice, just because of how your system just like duplicates pages in the record. So I imagine that if they had to, you know, redo an application because they want this victim advocate, and then let's just say that didn't work out, so they have to maybe they want another victim advocate or they just don't want one at all. They have to redo the application. It's just too complicated, and I can imagine hundreds of papers being used up in the record system because of this regulation. So I think you shouldn't pass it just to save time and resources and use them more wisely. So those are my comments, and I hope you take them into consideration. I also think that it would be a better idea if during these meetings you guys could respond immediately to the public's comments because it just makes for a better dialogue. And because usually when you're talking to someone, you don't it would just be it's not really it doesn't feel like a real conversation if you say one thing and then you're like, okay, another person says, okay, I'm gonna get back to you in 3 weeks, and then they say something, and then the other person says, okay, I'm gonna get back to you in another 4 weeks, and you're exchanging ideas about how to make something better. It's just quicker if you both can sit down and just put your heads together and really talk about issues and not have so much time in between responding to each other. I just think it would be more you might get better ideas and you might be able to make changes, um, more wiser changes that way. So thank you.
Thank you very much for your public comment. All right, I believe that is all of the in-person public comments. We're going to go to the public comment from the Zoom participants. I see the first hand raised was Ed Little. If you would like to unmute yourself and provide your public comment.
Thank you. My name is Ed Little. with Californians for Safety and Justice. Good morning, CalVCB members, and thank you for your dedication to supporting survivors in California. Californians for Safety and Justice and Crime Survivors for Safety and Justice would like to comment on the proposed changes and regulations to governing victims' compensation. We are a nonprofit organization working with Californians from all walks of life to replace prison and justice system waste with common sense solutions that create safe neighborhoods and save public dollars. We promote strategies to stop the cycle of crime and reduce reliance on incarceration and build healthy communities. Our work includes a growing statewide network of over 50,000 crime survivors. We support elements of the proposed regulatory changes that clarify support and address barriers to help survivors. We also oppose elements of the proposed regulations that are inconsistent with statute and would limit help to some of California's most vulnerable survivors. And we see several opportunities for CalVCB to strengthen language to clarify support for survivors. We oppose the proposed language that would deny help to formerly incarcerated victims and the loved ones of incarcerated victims. Current statute does not bar an applicant from receiving compensation after incarceration if they become a victim while incarcerated. It only says that they are ineligible to receive any award until after release. And in fact, current government code clarifies this by stating specifically that defendants convicted of a violent felony and serving any type of sentence may apply for compensation pursuant to this chapter at any time. But the award of that compensation may not be considered until the applicant meets the requirements for the compensation set forth in the statute, which is that they are no longer serving a sentence. This proposed regulation is counter to public safety goals. The proposed addition of CCR 694.4F would mean that after release from incarceration, if a person needs compensation for mental health care, medical care, counseling, or accessibility equipment on the basis of a violent crime committed against them while incarcerated, they would be ineligible for help even if they met all other eligibility criteria. It would also mean family members of individuals murdered while incarcerated would have no ability to seek compensation to bury their loved one with dignity. Denying healing services to formerly incarcerated victims and family members of incarcerated victims undermines public safety goals and denies help to some of California's most vulnerable victims. A national survey of people with past arrest and conviction records found that 9 in 10 people with an old record have been a victim of crime in the past, compared to less than half of people, 44%, who do not have a record. Half of people with a past conviction, 50%, cited trauma from prior crime victimization as a factor that contributed to their arrest. Nationally, more than half of victims with an old record, 51%, would have wanted but never received help from Victims' Compensation Program. We urge CalVCB to adjust the proposed regulations to address overly discretionary language regarding the behavior of the victim that results in disproportionate denials for survivors of color. We support the proposed regulatory change that ensures minor victims are not denied as passengers in DUIs due to involvement, 64649.50C. We also urge CalVCB to make additional changes to involvement determinations throughout the regulations to make these determinations more objective, address disproportionate denial of survivors of color, and reduce harmful impact of this policy. Statute outlines factors CalVCB may consider when determining involvement, but gives CalVCB discretion to determine which circumstances warrant denial and authorizes CalVCB to consider a range of mitigating factors to overcome involvement. Current regulations specifying what constitutes involvement are unnecessarily broad and vague, which can contribute to inconsistent interpretation and the door to bias. Indeed, data show that Black victims and families are significantly more likely to be denied under current rules. A 2021 Alameda County grand jury report analyzed victims' compensation denial data for survivors from Alameda County and found that Black applicants were nearly twice as likely as white applicants to be denied based on alleged involvement. 7% of Black applicants were denied compared to 4% of white applicants. and Black applicants accounted for half of all applicants denied for this reason, while white applicants accounted for just 8%. The grand jury concluded that disparities in compensation denials based on lack of cooperation and involvement are the primary drivers of racial disparities in victims' compensation denials for survivors from Alameda County, and that these restrictions are systemically racially biased. These determinations can send a message to survivors that they are not worthy of help to heal. Restrictions apply even in homicide cases, leaving parents and children of people killed without support for counseling or funeral expenses, and compounding the trauma of loss for survivors. When people who experience violent victimization did not have the resources they need to heal, it makes our communities less safe and contributes to cycles of trauma. CalVCB has discretion under current statute to address some of these issues parallel to policies other states have adopted, and we urge CalVCB to do so in this round of regulatory change. We are grateful for CalVCB's longstanding commitment to supporting survivors to access resources that they need to heal. We urge you to consider the above recommended changes to the proposed regulations, and thank you for your consideration.
Thank you very much for your public comment. I believe the next hand raised is Gabriel Garcia. You would like to unmute yourself?
Yes, thank you, and good morning to the board members and members of the public who showed up to voice comments today. My name is Gabriel Garcia, and I'm the Policy and Advocacy Director for Youth Alive. We are a community-based organization located in Oakland that is nationally recognized for initiating an alliance to address violence as a public health crisis and developing young leaders in the process. We are also a victim service organization. We actually assist trauma survivors through our homicide response program in Oakland called the Gaddafi Washington Project, and through our hospital-based violence intervention program for violently injured patients called Caught in the Crossfire. We provide critical support to them, families of homicide victims and survivors of violent injuries by connecting them to vital resources like the California Victim Compensation Program. And that we know that is really necessary and critical in order to promote healing in the immediate aftermath of a killing or violent injury. So we wanted to join today to say that we do support elements of the proposed regulatory changes that clarify, support, and address barriers to help survivors. We also oppose elements of the proposed regulations which are inconsistent with statute. So first, we want to highlight that we do support the proposed expanded interpretation of what constitutes good cause for late filing. We'd like to strengthen this change by including lack of awareness or notification to the victims. We want to see that direction of increasing access continue from CalVCB. However, we do oppose proposed language that would deny help to formerly incarcerated victims, as several speakers have already highlighted today, and the loved ones of incarcerated victims through 694.4F. So we support the included changes to denying individuals based on involvement, specifically for minor passengers and DUIs, but would like to see additional changes to involvement determinations to make these designations more objective, address disproportionate denials for survivors of color, and reduce the overall harmful impacts of this policy. These disproportionate impacts, as was just highlighted, were examined in a 2021 grand jury report in our county, Alameda County, and found horrifying disparities of Black applicants twice as likely to be denied as white applicants. We know that limiting the definition of involvement to circumstances in which there is clear and convincing evidence that the victim or derivative victim was personally causing or threatened serious bodily injury or death at the time of the qualifying victimization that initiated or directly caused the victimization is a much more effective way of and more objective way of creating and responding to some of the challenges with determining involvement and designations around that. I would highlight lastly that when we are serving victims of violent crime, we know that many times the trauma that folks have experienced needs to be healed in order to ensure that trauma does not spread. So, looking at violence like a public health crisis, which is the way that our organization operates and develops our approaches, we know that the strongest predictor of violence is a previous instance of violence. Our programs are designed around being able to help victims, those who have been impacted by violence, at the times that they are most vulnerable, because we know that what comes naturally to folks after they have been traumatized can often beget future violence. Things like when we are going to the hospital bedside of somebody who's been violently injured, a lot of the natural instincts to protect themselves, to avoid future injury, actually put them at more risk, like getting a gun for protection, joining a gang for protection, seeking retaliation against the person that harmed them. We know that these are all trauma responses that create greater risk for the person involved. But when we are able to provide healing resources to those individuals, we see that their likelihood of future violence gets cut significantly. So when somebody is violently injured, there's a 40% chance that they will become violently injured or die in 5 years. The national research on that has borne out that re-injury rates for violently injured patients are very high. When we are able to provide them healing resources through our intervention programs, that number gets cut down to just 2%. So, what we'd like to see from CalVCB is a trauma informed healing center response to those who have been violently injured, removing barriers to access these healing resources and programs that we know are life saving, not only for the applicant and the directly person involved, but the people in their community, because we know that these healing resources have a rippling effect. So, in conclusion, wanted to echo what Ed Little had just shared in his comments. Highlight that we need to remove barriers for folks who have been directly impacted by the criminal justice system. We need to make sure that we are expanding access for folks who were not made aware or not notified about the victim compensation program, or who may have been notified when the time limit was 3 years, is now 7 years. Want to make sure that those folks have access to these resources as well, and remove a lot of the subjective determinations of involvement that we know oftentimes are leading to disparities, like have been revealed in Alameda County, where again, Black applicants were twice as likely as white applicants to be denied. Thank you.
Thank you very much for your public comment. Would anyone else on Zoom like to offer public comment? If you would, and you don't see the hand raised option, you could unmute yourself and verbally request to provide the public comment. It does not appear anyone is raising their hand or unmuting themselves, but if someone would like to at any time, we are present to take that comment. So this hearing goes until 1 p.m., and so we will be prepared to take your comment at any time during this time period. We are going to take a we will take the short break and be back soon. Thank you. Thank you, everyone. We are back for the public hearing. And if anyone new that's joined or has been joined would like to make a public comment, please raise your hand, mute yourself, and we will be happy to hear your comment. This time, I don't see anyone with their hand raised or unmuted. We will continue to wait for any additional public comment, and the hearing goes until 1 p.m. For those that could not hear me last time, I just want to let everyone know that at this time we have no hand raised and no one is unmuted asking to make a public comment. We will continue to wait here for public comment until 1 p.m. Thank you. This is just a reminder to everyone that there are approximately 30 minutes left in the public hearing. If anyone would still like to make any comment, please either raise your hand or unmute yourself on Zoom. Thank you. Good afternoon. It is now 1 p.m. and this concludes the public hearing for the proposed revisions to Cal VCB's regulations. Thank you everyone for participating and for attending this hearing.